All right, welcome everybody. I am here today with another one of my video case alerts, and today I am thrilled to be joined by a guest, a fellow Edmonton lawyer, Mr. Paul Moreau, and we are going to be discussing a case that he will very shortly be litigating in the Supreme Court of Canada. And that case, of course, is the case of the Queen and Parranto. Paul is a veteran criminal defense lawyer, did time at the Crown as well. We won't hold that against you, Paul. I did time at the Crown as well. A lot of us did. Paul is a very, very well-known lawyer in Edmonton and has done tremendous work at every level of court. And this will be one of his many trips to the Supreme Court of Canada. Paul, welcome to the Case Alerts on Professor Sankoff's seminar.
Thanks very much, Peter. Happy to be here.
So today I want to talk to you about your upcoming case, which I think is a really huge case about sentencing. And I forgot to mention that Paul, in addition to being a prolific lawyer in Edmonton, also teaches the sentencing course at the University of Alberta Faculty of Law. I've been lucky enough to guest in his class at least once. We're going to be talking about the case of the Queen and Parranto, and we should probably mention for anybody who wishes to, have a look at this case before or after doing this case alert, that it's really tied up with two cases that were heard at the same time. Paul, am I correct that Mr. Felix is not appealing to the Supreme Court?
No, he is actually.
Okay, sorry.
And the two cases have been joined for argument in the Supreme Court.
Sorry, I forgot. So I'm focusing on Parranto because Paul is counsel for Mr. Parranto, but I think the Felix decision is the longer of the two decisions in terms of the principles, but they're all tied up together. Very quickly to outline the case, we're talking about two cases involving guilty pleas to large-scale fentanyl trafficking operations. There are different words used for those that I found amusing at the time, versus wholesale versus executive level trafficking. Not hugely important to what we're about to discuss. Mr. Parranto gets 11 years and the Crown wants 14. That's the essence of the divide. But the real issue is not the number of years for fentanyl trafficking. It's more about the extent to which there are starting points for fentanyl trafficking. And in this case, the trial judge disagrees that starting points should be used, says they are contrary to sentencing discretion. And the Court of Appeal says there is absolutely no debate that starting points are essential in Alberta. I should say two last things before turning it over to Paul to get some really important points about this. One, these decisions were decided before the Supreme Court of Canada's decision in Friesen, which has something to say about this matter, though perhaps not as much as we might like. And second of all, it was a quirk of scheduling that I happened to be there when Parranto and Felix were being heard. I had an appeal of my own that afternoon on a related matter, but not quite about starting points. So I got to watch this case as it was being litigated before 5 Court of Appeal judges, which I think is interesting indeed. Paul, I want to start by asking you, this is really about starting points. What, in your view, are the dangers of starting points for sentencing?
Well, there are a couple of dangers. You're right to say that this case is about starting points, and it's particularly ironic for me to be involved in this because when starting points, which have been around for a long time, first hit the Supreme Court of Canada, it was in a case called McDonnell. And as it happens, I was actually Crown counsel on McDonnell in the Supreme Court of Canada. So in that case, I argued in support of starting points and was questionably or modestly successful in that the Supreme Court there said starting points can be useful, can be a helpful guide, should not be considered binding, deviation should not be considered reversible error. Since McDonnell, in the mid-90s, the Alberta Court of Appeal took that up and said, well, the Supreme Court's approved starting points, so we're going to make them binding and reverse any trial judge who fails to follow a starting point. Now, in Parranto, of course, there was no starting point for fentanyl trafficking. So the Court of Appeal was asked by the Crown to create one. What are the dangers of starting points? That requires me to essentially reverse everything I argued in McDonnell. Starting points do have some benefits and some advantages, but there are some dangers as well. The significant danger of starting points is in their interpretation at the intermediate appellate level. So the Supreme Court of Canada said starting points are fine in as much as they may be considered like a range of sentence. They are guidance, but should not override individualized sentencing. The discretion of a trial judge must be employed, says the Supreme Court, to individualize a sentence and create a sentence that's fit for that offender and that offense. So starting points can be helpful in guiding judges, but they should not be considered a rule which deviation from which is reversible error at the intermediate appellate level. The danger is that starting points have a clustering effect. And there's quite a bit of sociology work that's been done looking at the phenomenon of deviation from starting points. And where you have a starting point, sentences inevitably tend to cluster quite tightly around that starting point. The second problem with starting points is the manner in which they are created. Sentence appeals are inevitably between one offender and the Crown. Sometimes, like Felix and Parranto, there are two different offenders and two cases are joined for argument. That's happened in a couple of other starting point cases in the Alberta Court of Appeal. But typically, a private litigant, an individual accused, or even a couple of accused, don't have the resources to bring information and evidence before the court that really should be considered in setting a starting point. We had in the past the Canadian Sentencing Commission, which heard from experts of a variety of different disciplines and issued recommendations. That's where sentencing guidance should come from, that kind of a broad-based inquiry that's working at a policy level. Appellate courts are not equipped by their very nature to receive and consider that kind of evidence in essentially litigation between the Crown and one private citizen. So the manner in which these are created is problematic. And if they're then employed, as they are in Alberta, to reverse any deviation from them, they become ossified. So an individual like Mr. Parranto comes before the Court of Appeal. The Court of Appeal sets a starting point, and in this case, it was 9 years for trafficking in fentanyl at a wholesale or executive level. Subsequent litigants then are essentially barred from even trying to challenge the principles that underlie that starting point. The Court of Appeal in Alberta has a very arcane and complex procedure that must be employed to reconsider any of its own prior decisions, particularly including starting points. That was discussed in our CAN. It's a very difficult procedure. It is, well, leave to reconsider is almost never granted. So the starting points are based on limited evidence, insufficient, in my view, evidence, and then become ossified and enforced forever to the detriment of every other litigant in the future.
Yeah, so I'd say there's two big problems, and you've spoken at length on the second one, and I certainly take your point on that. I just want to focus a little bit more on the first one, because there are, of course, listeners to these alerts from other provinces who are not as familiar with starting points as we are. One of the things that certainly concerns me, and I'm sure it concerns you, Paul, is the extent to which you're able to deviate from a starting point to begin with, because that starting point seems to include a lot of things, including a guilty plea, a person of good character. Like how realistically possible is it in most cases? I'm assuming the starting point does not include Indigenous offenders, so there is some leeway there, right? That is normally true. So Indigenous offenders have room, but in your experience, how much room is there to deviate from the starting point, or does that just become the de facto sentence?
Well, back when I was arguing in favor of starting points, I used to point to the starting point for cocaine trafficking at the commercial level, not the wholesale level. So the starting point sentence there is 3 years as set by a case called Maskell. However, back when conditional sentences were possible for cocaine trafficking, the Court of Appeal heard a group of cases and released a decision in, I think it was 5 cases altogether, known as Rahimi. And in all those cases, the Court of Appeal held that a conditional sentence of 2 years less a day was fit and appropriate for cocaine trafficking, acknowledging the 3-year starting point. Guilty pleas are not built into starting points. That's an important thing to understand. And in all the Rahimi cases, they were guilty pleas. So I used to point to that, to Rahimi, as evidence of the flexibility of the starting point approach. However, in practice, it has proven to be less flexible than we would like to see. We've seen a number of cases of drug trafficking, cocaine trafficking, particularly, on a very, very low level with enormous mitigating factors where trial judges have imposed sentences like 90 days, and the Court of Appeal has reversed that and imposed penitentiary sentences.
Yeah, because the starting point's 3 years for cocaine trafficking.
That's right. And as conditional sentences are no longer available, of course, right? Although they might become available again. Yeah, if Bill C-22 passes. So we'll see about that. But the real problem is that starting points tend to force sentences to cluster very tightly around that starting point. And that is to the detriment of individualized sentencing.
Yeah, especially when you consider all the factors that normally go into it, including, I mean, leaving aside the obvious differences in characteristics of the offender, there's just so many variables with respect to the nature, especially one of the reasons I get so upset about starting points is because with party liability, the nature of your participation in the offense is so variable that to start sticking people with, starting points. Again, in theory, starting points should be able to accommodate for that, but I find that number just becomes very attractive to the trial judge and hard to deviate from.
That's the real problem. Yeah.
Okay. So what can you give us? This is the Alberta position. You're going up to the Supreme Court. And I don't know about you, but I'm guessing one of my favorite things to do at the Supreme Court is point out how out of line Alberta might be with other appellate courts. How out of line is Alberta with other appellate courts on starting points?
Well, pretty far out of line. In my factum in Parranto, I did a bit of a survey of this, so I can tell you, British Columbia has expressly disapproved of starting points and refused to endorse that approach. The Yukon does not subscribe to a starting point approach. Northwest Territories, not surprisingly, do endorse it. And I say not surprisingly because the judges of the NWT Court of Appeal are the Alberta Court of Appeal. Nunavut courts have been hesitant to adopt the starting point approach because sentencing must be an individualized process. In Saskatchewan, the Court of Appeal there established a starting point sentence of 3 years for major sexual assault, but in relation to other offenses, their approach has been to recognize a general range based on established jurisprudence rather than to establish new starting points. Manitoba has starting points for some offenses, but not others. And that was extensively discussed, of course, in Friesen, which is an important case that I assume we're going to talk about in a minute. In Ontario, the use of starting point sentencing has been controversial and has never been fully endorsed by the Ontario Court of Appeal. They have taken a different stance with regard to starting points. Quebec has repeatedly and in no uncertain terms taken a strong stance against starting point sentencing. Newfoundland expressly does not use the starting point approach, but adopts what they call the acceptable range approach. Prince Edward Island has rejected a starting point approach to a sentence that has incarceration as a starting point. New Brunswick has declined to adopt the starting point approach in favor of sentencing ranges, which are non-binding guidelines. Nova Scotia has not adopted the starting point approach either. So Alberta is an outlier in that context. It always has been. Alberta started the whole process of starting points back in, I think it was 1982. Sandercock was the first one and has established, of course, an elaborate architecture. Depending on how you count them, there may be as many as 30 starting point decisions from the Alberta Court of Appeal. No other province has really taken up that mantle in any meaningful way, other than, as I say, Manitoba in a very limited way.
Yeah, we could get into an interesting discussion about the way in which starting points as a rule of law seem to me to get away so strongly from what the Supreme Court has said about deferring to decisions by the trial judge with relation to sentencing, because they essentially insert legal rules into the framework of sentencing and then say that failing to follow them is reversible. Isn't that one of the issues that arises?
Yeah, that's certainly true. And one of the criticisms of starting points is that the Alberta Court of Appeal has not stayed in its lane, in the sense that they have essentially created new criminal offenses. So by defining a particular type of, for example, sexual assault, and saying this is a major sexual assault, we'll define what it is and we'll ascribe a starting point sentence of 3 years. And one of the criticisms has been that is Parliament's business. That is not the court's function.
So I remember last year we did the top 10 cases of 2020, and Friesen was in that top 10. And, I can't say I read Friesen on a daily basis, but I thought Friesen had some things to say about starting points. What is your view of how Friesen from the Supreme Court of Canada, a 2020 decision, impacts on the question you're raising in May?
Well, Friesen was a very interesting decision for me in this context because it did consider the Manitoba starting point in relation to sexual assault cases. The Alberta Justice Department intervened in Friesen, filed an intervenor factum, arguing very eloquently and strongly in favor of upholding the starting point approach, and citing, of course, the Alberta Court of Appeals magnum opus in defense of starting points, Arcand. Arcand is a 2010 decision which spends about 160 pages defending the starting point approach and is generally considered the, well, as I say, the magnum opus on starting points. The Supreme Court, on the topic of binding legal effect or standard of review, expressly ruled that Arcand is wrongly decided. To the extent that a trial judge declines to follow a starting point, that is not a reversible error, and Arcand is wrongly decided to that extent. Now, Arcand says a lot of things, and it's not restricted to that. So some things in Arcand are still good law in Alberta. But one of the central points of it has now been expressly overruled in Friesen. Now, the Supreme Court in Friesen declined to take up a broader discussion of starting points in general terms and said that they will leave that for the appropriate case. So when I applied for leave to appeal Parranto, I cited that and said, this is now the appropriate case. Well, they granted leave, so I'm guessing that they agree this is the appropriate case to engage squarely with starting points.
Well, that's true. I was about to say that pretty much guarantees a win in Parranto. But of course, in Parranto, there was no starting point. So the issue of the Court of Appeals interference is not strictly on failure to follow a starting point. Isn't that right?
Well, that was one of the very odd things about the Court of Appeals decision in Parranto. At the time Mr. Parranto was being sentenced at the trial level, there was, of course, no starting point decision on fentanyl trafficking, not on any scale, commercial, wholesale, executive, there was nothing. So the Crown, of course, had been working for a number of years to try and get something established. And of course, we all recognize starting points are not set by trial judges in Alberta. They're only ever set by the Court of Appeal. But the Crown urged the trial judge here to adopt a notional or presumptive starting point. He said, no, I'm not going to do that for a couple of reasons. Firstly, starting points are the business of the Court of Appeal. That's not my business. Secondly, I think that the whole concept of starting points is contrary to the notion of individualized sentencing and an exercise of discretion. The Court of Appeal found that was an error and said that the trial judge was wrong in rejecting the starting point approach, even though there was no starting point.
I was about to say, how can that have an impact on the sentence that was imposed? That's just so weird to me. Yeah,
I know. That is one of the points that I'm arguing pretty strongly, is that the Court of Appeal was wrong to interfere with the trial judge's decision here on a reason that essentially didn't exist.
In other words, your backup position at the Court of Appeal was effectively, well, you can set a starting point if you want, right? I think it's the wrong thing to do, but it has no impact on the sentence of this individual because it didn't exist at the time he was sentenced.
That's correct. I was arguing that. I was also arguing it was premature to set a starting point for fentanyl because it's all too new. Yeah. And as well, I argued that if we're going to set a starting point, it shouldn't be substantively different than the existing starting points. There's a starting point for heroin trafficking, a case called FAM, and the starting point there is 5 years. So when FAM was decided, heroin was effectively the worst drug that we knew about. So the Court of Appeal in FAM decided the level of moral culpability, the seriousness of the offense for trafficking in the worst drug we know of is 5 years. So now we know about a different drug that is probably objectively worse than heroin, but is the moral culpability really any different? I argued that it should not be, but the Court of Appeal disagreed with me.
Well, Paul, this is absolutely fascinating, and I suspect a case that's going to have a real impact on the legal landscape. So kudos to you for bringing it up. You'll be surrounded, I imagine, by a host of interveners that are eager to put their stamps on this particular point. I'm always interested, though, Paul, because I'm guessing that a bunch of AGs are seeking to come in on this. I'm always interested for that case where one of the AGs goes rogue and takes one of the positions of the defense counsel. I'm not saying this is going to be that case, but like, isn't there a possibility one of the AGs from like Quebec or Ontario will say, you know what, we're sort of on side with the defense here, which always
You know,
leads to strange bedfellows.
it does, and I would find it great and hilarious as well if for example, if Quebec came in and said, "Yeah, we want to intervene and argue on essentially Mr. Parranto's side." That would be hilarious. I am, of course, expecting that Alberta will apply to intervene. I've been told that they will. That their deadline is coming up this week. Manitoba is also pretty likely to apply to intervene, and intervention applications have already been filed by a number of groups. The Aboriginal Legal Services Clinic in Toronto,
Sure.
Alberta Legal Aid, and the Criminal Trial Lawyers Association and the Canadian Civil Liberties Association have already filed intervention applications.
Yeah, well, I look forward to seeing if any Crown turns sides. That's always my most exciting moment. But anyway, Paul, it's been a great pleasure. Thank you so much for joining us on our case alerts and sharing your expertise with us.
Thanks for having me, Peter. It was fun.
All right, good stuff.